All right. Hello. Welcome. Thank you for joining us for the fourth out of six webinars in the Own Your Sound, Master the Business of Music webinar series, which is co-presented by Colorado Attorneys for the Arts and the Colorado Music Industry Alliance. I'm Meredith Badler. I'm the Deputy Director at the CBCA, which runs Colorado Attorneys for the Arts. And I'm happy to kick things off for tonight. Thank you all for joining us. Just a few housekeeping items as we get started. We are recording tonight's webinar. So just be aware of that for those joining us live. If you are watching this later on our YouTube channel, hello to you. We're so glad you were able to find your way to this content, and we hope all of you find it useful. Given that we are recording tonight's webinar, we do ask that our participants this evening stay on mute, and we encourage you to keep your camera off as well. This sort of helps us all stay focused on the really wonderful and important content for this evening. There will be time for Q&A at the end, and that's a great time where you could unmute yourself. You can also use the chat to say hello, introduce yourself, let us know who you are, where you're coming from. And that's also a great way to ask questions. You can put your questions in there throughout. And again, we will leave plenty of time for Q&A at the end. And finally, we ask you to just be respectful to others on the webinar this evening, support our shared learning. So show up in that regard. And we do have, after tonight, there are still two more left in this series of six. So we're in the back half, but we're covering a lot of different territory. Tonight, we're talking all about recording your music. We'll get into that in a moment. And just a quick commercial for our two organizations that are co-presenting this series. So the first is Colorado Attorneys for the Arts, or CAFTA, as we call it. CAFTA is a program of the CBCA, all about providing legal education and legal assistance for our creative community. Artists, musicians, filmmakers, painters, writers can apply through CAFTA to get connected to one of our volunteer attorneys with a specific legal need, sort of seeking legal representation for their creative work. And then we also do consultations, webinars like this one, legal education for the creative sector as well. So all of that is through CAFTA, which is a program of the CBCA. And we are also co-presenting this series with CMIA, the Colorado Music Industry Alliance, which is a new organization really intended to be a one-stop shop for the music industry in Colorado. So bringing together all of those different parties and entities from individual musicians, venues, radio, all together. And so we're partnering on this series. So I'll throw some links in the chat when I'm done talking. So you can look up those two organizations. But you did not come here to listen to me. I am not an attorney, but we are joined tonight. We've been alternating between our two attorney speakers. So tonight will be led by Dave Ratner with the Creative Law Network. And today is all about recording your music, what you need to know, as you can see here, producer and engineering agreements, those very important contracts, licenses, samplings, again, everything you need to know to record your music. So with that, Dave, I'll turn it over to you. I will stop sharing my slides so we can see yours. And yeah, take it away.
Well, thanks, Meredith. I appreciate it. And thanks to everyone for being here. As Meredith said, we are covering a lot as quick as we can, but trying to make sure that we're getting everybody's needs covered here. I want to make sure I can, let's see, I need to open up the chat as well. Why is that not working here? Oops. Sorry, it's give me a second here to get myself technically, there we go. Okay, great. So I was going to say, if everyone who had joined us just more recently, if you want to introduce yourself in the chat, tell us a little bit about yourself, please feel free. And we'll definitely welcome any helpful hints in the chat as well. Please put questions in the chat. I will try and answer them along the way, or we'll save them till the end. Sometimes we get questions that I know I'm going to cover on a later slide. So I don't want to break, don't want to jump ahead, but certainly I don't want to miss anything either. So please do put your thoughts and your questions in the chat. We will keep an eye on that as well. And as Meredith said, my name is Dave Ratner. I run a law firm called Creative Law Network, and our law firm basically provides legal services to creative people and businesses. So we do a lot of music law, and I'm actually, I worked in the music industry for quite some time. Before I went to law school, I was a band manager. Before that, I was a tour manager. Before that, I was a roadie. So I've definitely seen the industry from a number of different angles, and we see the legal scene from a number of different angles. I think one of the tough things about music, the music industry, is that it can be complicated. It can be confusing. And it's not only the law of music, but it's the music industry and that intersection that we're trying to cover here today, or cover during this series. So as Meredith mentioned, this is a 6-week series. And if you missed weeks 1, 2, or 3, they are available online. Please check them out. If you have to bounce off today, this one will be available as well. And please join us for weeks 5 and 6. There's some good stuff coming up then as well. So let's see if I can make sure to, there we go, get ourselves going. Today, we are going to be talking about pretty much contracts related to recordings. So the past few weeks, we've definitely been trying to lay the foundation, lay the groundwork for moving into this area of the industry. And I'll do a quick review as we get things going here, just because I know I do see a lot of folks who have been here before. So thank you all for returning. I'll see some folks, some names I haven't seen before. So thank you for joining us. And so I'll try and kind of balance that out so we're all hopefully working from the same baseline. So today we will review some copyright basics, because copyright is really the foundation of so much that we do in the music industry. So we want to make sure we're all on the same level, at least have the same basic understanding of copyrights and the law around copyrights, and also the terminology, because the language that we use in the industry can be a source of confusion. That can be a complicating factor. So describe some of that language as well that we use to describe the various copyrights and the various revenue streams that run from those copyrights, because it is nice if we can make money in music, right? It may be fun to make and play music, but ideally we're doing it for a living as well. So because a lot of today's context is around contracts, I will talk about contracts generally, and that will provide us with a bit of a framework to talk about these specific contracts we're talking about, which are producer agreements and mixer agreements, sync licenses or synchronization licenses, and sampling, which sampling also requires contracts. Contracts, agreements, same thing. And so I want to make sure we are covering all those things in somewhat of a logical order. So hopefully, like I said, we will get to everything that is on our agenda here today in the amount of time that we have allotted. So we'll dive in here and get started by saying that, well, like I said, refresher on copyrights, okay? So copyright is it's intellectual property, okay? So copyright is a type of property. It's something we can own, just something we can't touch, right? Because just like other things you own, like a chair or a desk or a house or a car, it can be bought and sold. It can be rented, licensed, same thing, and we can make money from it. But it is property that is intellectual property, so it's not actually tangible. And copyright protects all sorts of different creative works. This list that is on the slide right now are the 8 different types of creative works listed in the copyright law, in the Federal Copyright Act, that are protected by the copyright law. And what's important here is it's worth noting that if you look on this slide, number 2 says copyright protects musical works. Number 8 says copyright protects sound recordings. That means there's 2 different copyrights that we're dealing with when it comes to music. So I'll get back to that in a couple slides, but just keep that in mind that we are dealing with copyright protects, or there's 2 different copyrights in music. All these different creative things are protected by copyright. So one question I think we want to make sure to answer is, who owns a copyright? What does copyright ownership mean? So a copyright exists as soon as a work is created. So we kind of say, as soon as you lift your pen from the paper, there is a copyright in that thing you wrote, or as soon as you press record on whatever device you're using, you're recording, you're creating something, and once it's fixed, there's a copyright in it. The copyright law says that it must be fixed in a tangible medium of expression, basically fixed in some way you can show it to someone else. Because I understand most of us are not using pen and paper anymore. So there isn't necessarily a physical manifestation of that thing we created, but if it is recorded, if it is captured, then there's a copyright. Well, if it is recorded, if it's an original work, so something creative and original and is captured and fixed, is protected by copyright from the moment of creation. It's kind of intuitive to say this, but I will make sure to say it, that the creator of the copyrighted work is generally the owner of the copyright. And again, seems intuitive, but also there are some situations where you sometimes forget that. And I'll talk about that in a little bit. So it's always important to remember everyone who's contributing to the creation of the work is an owner of that work, which means if there's multiple people creating, there's multiple copyright owners. So again, kind of intuitive, if a bunch of people are writing a song together, we're all going to own the copyright in that song. Also, if a bunch of people are contributing to a sound recording, everyone contributing is going to own, by default, will own that sound recording. So important to think about if, for example, you have a, I don't know, 4-piece band, but you bring in some strings or some horns to perform on a recording. Well, by default, anyone who contributes to the creation of that sound recording is a co-owner of the copyright. So we want to be thinking about who are the owners, who are the creators, because those will by default be the owners. Now we can change that through contract. And I'll talk about that in a little bit in a couple of slides here. So I'll move on to the next one, which is what we have when we own a copyright, which is that we have a set of exclusive rights. Now, exclusive rights means the owner of the copyright is the only person allowed to do these things, to exercise these rights. Again, kind of intuitive, but I think it's helpful to lay it out. Again, this is straight out of the Copyright Act. So I'm not suggesting it's fun or exciting to read statute, to read the law, but these things are helpful because the owner of a copyright is the only person allowed to reproduce that copyright. So if you create a sound recording and you own that sound recording, you're the only one allowed to make copies, right? You're the only one allowed to distribute those copies. You're the only one allowed to perform that song. And also, number 2 on this list, prepare derivative works. A derivative work is a work based on the original. So if you write a song and you own the copyright in that song, you have the exclusive right to create derivatives based on it. So whether that is changing the words or rearranging the song, you have the exclusive right to do that. Similarly, if you hear someone else's song and you want to create a new arrangement around it, we have to think, do we need permission from the copyright owner to do that? So I think about it from both sides of copyright ownership. But it's just, again, helpful, I think, to look at these things to understand where we're coming from when we're talking about the ownership of copyright. Let's see, the term of a copyright lasts for a very long time. It lasts for 70 years after the life of the author, which again is a very long time. That means if I write a song today, I will own the copyright in that song. That copyright will continue for 70 years after I die. So a very long time. Another thing to note about ownership is that we can register copyrights with the US Copyright Office. We aren't required to. As I said, we have the copyright as soon as we create it, but a copyright registration is legal proof of ownership. So if we ever need to enforce our copyrights, for example, in court, which hopefully we never do. But if we do, then we need to have that registration. It is useful to put a copyright notice on your work, whether it's on an album, if you're writing an album cover, your liner notes, or in the metadata, copyright notice is a good thing to have. So just a couple notes on copyright ownership. And one more note on copyright ownership, which is the transfer, buying and selling, changing ownership, I should say, of a copyright. And this is important because transferring a copyright, changing ownership of a copyright has to be in writing. So in a situation where, let's say, two people are contributing to a song, but only one of them wants to own that song, the other person would have to transfer that in writing. The exception is if it is a work for hire. But this is a really important term that I feel gets thrown around a lot and maybe not always with enough clarity. A work for hire exists in two situations. A work for hire exists if you are employee creating the work within the scope of your employment. So that doesn't usually happen in music because most of us aren't full-time employees in our musical work. I mean, if you were, I don't know, if you are a composer for Disney or someone like that, then yes, perhaps it is your full-time job, W-2 employee, to create music, and your employer, Disney, would own the results of your work. But a lot of people say, oh, well, it's a work for hire just because I paid you. Just by paying someone doesn't result in the transfer of a copyright. The transfer has to be in writing. So we can have a contract. We can say, hey, I'm going to hire you to play horn on this track. I'm going to pay you. I'm going to own the copyright. It is a work for hire. And there's a contract. There has to be a contract to transfer that copyright. So really important when anyone is contributing to the ownership, or sorry, if anyone is contributing to the creation of a copyright, and that person is not supposed to be an owner, we need to have that in writing, unless they're an employee creating it in the scope of their employment. So most of these situations, we want to have something in writing. And as I'll talk about in a little bit, contracts don't have to be complicated. They have to have some basics included, but we want to make sure that transfer is in writing in almost all situations when it comes to music. So that will come up a little bit later. The other thing, this is very important, that I alluded to when we were looking at that list of the 8 different types of work that are protected by copyright, is that there's 2 copyrights in every piece of music. Okay, the first one is what we often call the song. It's the composition. So the music that is written, if we think about written down, which I know a lot of us don't actually write down the music that we're composing, but the written word or the written music is what we think of the composition. And the composition is often referred to as the publishing. So this is where I was talking about the different terms that we use for oftentimes the same thing. So the composition, the publishing, same thing. So whoever writes a song is going to own that composition or own the publishing rights. And if multiple people, if one person writes the music, the other person writes the lyrics, we co-own that composition. There's a completely separate copyright in the sound recording. So if I write a song, I own the copyright in that composition. If I hand it to you and you go record my song, you own the copyright in the sound recording. Completely separate copyright. This is very important when it comes to the producer agreements. We're going to talk about the sync license. We're going to talk about the sampling. We're going to talk about, because all of those uses involve both of these copyrights. So we always have to be thinking about both copyrights, how each of these copyrights are impacted by whatever situation we're creating or situation we're dealing with. So the sound recording is often called the master. Again, these are synonymous. They mean the same thing. The sound recording is the more technical term, but the master is more term of art that we use in the industry, as I'm sure you all know. So I will kind of use those interchangeably. I will try and clarify as we go. But again, this slide is one of the most important slides in anything I talk about when it comes to music, because it is one of the biggest points of confusion in the music business and certainly in music law. So keep this one in mind. Write it down, write it in your hand, whatever it takes. But I know that most of what we're talking about today is contracts. So I want to talk about contracts generally, because a contract is an agreement. It's a written, generally written down in some way. And really, people often ask me, well, when do I need a contract? And of course, as a lawyer who drafts contracts, I'm going to say you always need, well, not always. You very frequently need one anytime there is a deal between two or more parties and something of value is changing hands. And that may or may not involve money. Hopefully it does. But anytime something of value is changing hands and we're having an agreement between parties, we are forming a contract and we do want to have it in writing if possible. There is, I would say that verbal contract, handshake deals are enforceable in some situations. As I said, it's not enforceable for the transfer of a copyright. That has to be in writing, but we do know that we do have verbal contracts that can be enforceable. I just don't encourage people to rely on verbal contracts because if there's ever a dispute about what the parties agreed to, there's no proof of what we actually agreed to, and it makes it very hard to resolve the situation. While I am a lawyer and I can talk about disputes in court and all these are the things, if I'm doing my job well, we're not going to court. We're not having disputes. Although a lot of us may think of lawyers as, well, we see on television, we see lawyers on television, they're always in court, they're yelling, I object, and that's not what I do. That's not what most lawyers do. My job is to protect my clients, to help them draft good contracts, because like we say that good fences make good neighbors, good contracts make for good deals. We write down in the contract what the deal is. It's much less likely we're going to have a dispute in the future. If we do have a dispute, it's much easier to resolve that dispute if we have it in writing. So you're all here because we're going to talk about producer agreements and mixer agreements, and these are all contracts, and this is why you're here. So maybe you already know this. So basic of a contract is when we have a meeting of the minds. Two or more parties have an agreement on basic terms. Okay. One thing what we learn in law school, if you ever went to law school, your first year you take a contracts class. I don't recommend going to law school. I'm just going to save you the time here. You ever went to law school, you take a contracts class and they tell you that a contract is created when you have offer, acceptance, and consideration. Consideration means something of value. So one party makes an offer, the other party accepts the offer, there's something of value changing hands, we have a contract. And ideally, we're going to write it down. A partner I used to work with when I was a baby lawyer, just getting out of law school, would tell me that a contract tells a story. Okay, so it doesn't have to be super complicated. We just have to tell the important parts of the story. So when we get to the end, we know what happened. And one thing I always want to emphasize about contracts is that I would imagine that most of you who have seen or had to deal with contracts have run into a lot of complicated language. Because contracts are often written in legalese, right? The wherefores and the therefores and the herewiths and the herein's and all these other things that you really don't need to have a contract. Now, ideally, if you are dealing with a contract, I want you to have the best possible contract. There is value. There's a reason lawyers use that language. It's very comprehensive. It means certain things. We cover all the bases. But I also understand maybe you're doing a super simple deal. You're going to do a super simple contract. You're just going to write it yourself. That's fine. You don't have to hire a lawyer for every contract. Okay. But if you're going to write your own contract and you're not a lawyer, you don't have to write it in legalese, right? I don't speak French. So when I write a contract, I don't write it in French, right? And so when it comes to writing a contract, you don't speak legalese. You don't have to write it in legalese. So that is one thing to keep in mind when dealing with contracts. I will also say there's a lot of information on the internet. The internet is a beautiful, wonderful, terrible place that has a lot of contracts on it. You may find some good contracts on the internet. You may find some terrible contracts on the internet. So buyer beware. As we're doing this, you may say, oh, well, I've downloaded it. It's easy. I got it. Cool. However, one of the reasons we have Colorado Attorneys for the Arts is that if you need a contract and you need a lawyer and you can't afford a lawyer to write that contract, you can go to Colorado Attorneys for the Arts and get free legal help. So keep that in mind. If you're coming up, I need this producer agreement drafted, but I don't really know how to do it. Go to Colorado Attorneys for the Arts, and we can find you a lawyer to do it for free if you financially qualify. So I was saying a contract tells a story. We just need to include the major deal points. I remember when I was a very, very long time ago, when I was in high school, I took a journalism class or something, and they said, you just have to cover the who, what, when, where, why, right? Then you'll cover everything. So when we're thinking about what goes into a contract, just include the major deal points. Think about the who, what, when, where, why. Think about what are all the pieces of this story, so that when we have this contract written, if we handed it to someone who had no idea anything about this deal, they'd be able to read the contract and understand it. But we don't want to have a situation where it's like, oh yeah, I know the deal, you know the deal, we'll just write, the amount I'm going to pay you and the date. That's not a contract. We want to have all those details in there. So when I talk about the who, what, when, where, why, I'm talking about who are the parties, what does each party have to do, when do they have to do it, what has to be delivered, when does it have to be delivered, how much is being paid, when is it being paid. And I think that, and Jamie's right, that also the how is it all going to happen? I completely agree. That goes in here as well. And one thing to think about when you're reading a contract or dealing with a contract or thinking about a contract is you want to cover what happens if something goes wrong. Okay, because for the most part, when we sign a contract, we're hoping we sign that contract, we go through the deal, and everything goes great. Everyone gets paid, everybody's happy. We never have to look at that contract again. Most of the time that we pull the contract out of the file, like I have a physical file, we pull it up on our computer, it's because someone didn't do what they were supposed to do. Someone didn't get paid. Someone didn't deliver the right thing at the right time or do it the right way. Okay, so the contract tells the story, it includes everything that's going to happen. And we want to also think about, and in thinking about, okay, what do I need to include in here? Think about what could go wrong. Okay, and that's how I approach agreements. That's how I approach drafting contracts. So take that for what it's worth. You know, do everything my way, but take that for what it's worth. So let's jump into some of the topics we're talking about today. We'll start with producer agreements. So like the contract tells the story. The story is a producer is being hired to produce one or more masters. I'm going to kind of jump and assume that everyone either has worked with a producer, is a producer, knows what producer does. So that's not the topic of the conversation today. But in a producer contract, we're going to talk about who are the parties. The producer is certainly one of the parties. And then who's hiring the producer? It's usually the artist or the label. If the artist is working with a label, sometimes the label will hire the producer. It's not usually both. It's going to be one or the other. And we want to talk about what is going to be done, what is going to be delivered. So how many masters? Is it just going to be a full album? We don't necessarily need to know the names of all the masters. We don't even necessarily, I mean, we could say enough masters to make one album. And as long as we can figure out what that is and the payment aligns, that's fine too. But again, setting expectations, including the details, is going to be really important. Also, what has to be delivered? So basically, are the tracks going to be mixed and mastered? We're going to talk about engineering agreements next. So if the producer isn't mixing, great, and may not be mastering, but let's be specific about what exactly is going to be delivered and also when is it going to be delivered, right? Because unfortunately, I've had clients who hired a producer and maybe even paid him a bunch of money, and 6 months later, we're still waiting for those tracks. We don't want to end up in that situation, thinking about what could go wrong. One of the things that goes wrong is the time we don't stick with the timeline. Okay, so think about what's going to be delivered, when it's going to be delivered, and very important. Well, how does payment work? And payment in producer agreements can be a little tricky. So generally, most of the time, a producer is going to be paid a flat fee, and that may be per track. It may be for the whole project. It's not generally hourly, but it could be. And so what is that flat fee? And again, if it's, for example, if we're saying it's per track, well, then we could do 1 track, 2 tracks, 10 tracks, that producer is going to get paid that amount per track. But also there's oftentimes a royalty. A royalty is a percentage. A royalty is an amount based on revenue that is generated. So we're going to want to talk about how that royalty is calculated. One thing about the flat fee and about any payment is we want to make sure there is a payment schedule, a timeline. So for example, maybe there is a certain amount that's paid upfront and another amount that's paid upon delivery. When my client is the artist hiring or the label hiring the producer, I'm always going to hold back some of that payment until delivery because I want to make sure we actually get the delivery on time. And if you've paid all the money up front, the producer may not be as motivated to deliver on time. So thinking about it, again, I know there's people on this call that are both producers and artists, probably not too many labels, but on both sides of these deals. So think about your side. Think about what you're going to need in this situation. The royalty, as I said, is a little bit more complicated. So one of the most common terms you may run into in a producer deal is what they call producer points. Points on the deal, okay? And that is basically a back-end payment is based on royalty, is a royalty based on revenue generated, okay? Points is a bit of an antiquated concept because points is actually a percentage of the retail price. This kind of comes from the days when we bought a lot more CDs or cassettes. Vinyl, I know we still do sell, but where there is a retail price, the retail price for streaming and downloads is a little different. Okay, so it's not as easily calculated, is still a way that we frequently pay a producer royalty. But because there's so much self-distribution, because there's so much less physical product and retail price calculation, we're also often using a percent of revenue as a deal point or as a calculation of royalty. So the calculation that percentage of revenue is calculated on that royalty is calculated on a percentage of the revenue generated by the masters that the producer creates or the producer contributes to, the producer produces. And so when we say, okay, you're going to get 3 points or 15%, right? Well, that 15%, is that a percentage of gross or net? We need to be specific. Gross revenue is all the money that is generated from the track. Net is gross minus expenses. So we may, hopefully this track is going to make a lot of money, but if we spent a bunch of money on producing and mastering and studio time and maybe even manufacturing, well, a lot of times the artist or label gets to recoup that money before we start paying a percentage, before we start paying the royalty. So there's a lot of details in here we really want to pay attention to because it really will matter. I mean, it makes a big difference in how that money comes out. And so more common, you're going to see a percentage of net. Obviously, that's more in the artist's favor. Just because, look, when I'm representing an artist and a producer says, well, I want a percentage of gross. Well, the problem with my artist paying you, the producer, percentage of gross is you're going to start getting paid a royalty before my artist makes any money because the artist is still recouping all those expenses they put into this album or these tracks. And so there's arguments on either side, or on both sides, I should say. But just to kind of familiarize like how these things work and why it's not just like, this is why there isn't just, oh, here's a producer agreement. They all look the same. They just don't. Every deal is different. How much is the artist investing in this? Is there a label involved? What sort of distribution plan do we have? All those sorts of things matter in these sorts of deals. So a little bit more about the royalty. Other important points to think about is who's going to pay the royalty. Okay, because certainly if the artist is working with a label, it's easier for the label to pay the producer directly. That's something that the label would have to agree to. If the artist is self-distributing, the artist could pay the producer. But if the artist is self-distributing on DistroKid could pay the producer directly if the producer has a DistroKid account, right? So thinking ahead about these things is really important, and putting it in the producer agreement is really important. Because this is when I say think about what could go wrong. What could go wrong is you're the producer and it says you're supposed to get 15% of net, and you see there's however 1 million streams on Spotify already, and you haven't seen any money. And well, where's my percentage come from? Well, if all the agreement says is you get a percentage of net, but doesn't say how you get it or when you get it, it's a lot harder to enforce. So another point that we want to have in this producer agreement is the payment schedule. Are royalties paid monthly, quarterly, annually? I don't know. Let's be specific. Right now, we may say it's paid on the same schedule that the distributor makes payments because the distributor is going to pay the producer. That's fine, but let's specify. Right? Let's be detailed about that. And it's not only how frequently, but also by when, because if it's, for example, if it's monthly, it's not going to be on the first of the month, generally, because we will need a little time to calculate. So maybe it's within 15 days of the end of the month. Or if it's annually, it's within 45 days of the end of the year. These are details that matter, especially when it comes to money, right? The things, when any contract I'm looking at what does each party have to do, when, and what's the deal with the money, and also can we terminate it? But that doesn't really matter as much of the producer agreement. So think about how this money is going to be paid and by who it's going to be paid. Another thing about royalties, and this is in lots of different agreements, is that if one side, in this case the producer, is going to be paid a royalty, which is a percentage of revenue, can the producer audit, in other words, look at the books and records? Because again, in the situation where the music seems to be making tons of money, but the person's not getting paid, well, they're going to want to say, well, why am I not getting paid enough? So generally, when we have a contract that includes a royalty, there's going to be an audit provision. The audit provision is basically saying that the producer can look at the books, or really hire an accountant to look at the books and records relevant to the money they're supposed to be making. And that clause, and this is where, the kind of as someone who writes contracts all day, these are the things that I'm very used to, is we talk about how can a producer audit the books and records, when, and how much notice you have to give to do that. How many times can you audit in a set of, can you audit you can't audit every month. Can you audit once a year? Can you audit one statement more than once? These are details we put in there. Hopefully, we never have to deal with an audit. Hopefully, everybody gets paid and everybody's happy. Again, contracts are valuable because things go wrong. We want the contract to dictate what happens when something goes wrong. So including an audit provision is a good thing to have in there as well. Chris Jones, I think you came off of mute there. Thanks so much. So let's see. Oh, really important, sound exchange. Okay. So we talked about sound exchange a couple weeks ago. I think it was 2 weeks ago. That sound exchange pays a performance royalty for the master. Okay. So what that means is when a master is publicly performed, so played out of a speaker somewhere, performed by digital audio transmission, so not just played over the radio, terrestrial radio, but played over internet radio, it generates a royalty. Sound exchange collects that royalty. Okay, so there's money being made from the master. When an artist is getting paid a royalty, they're getting paid a percentage of all the money that comes in from the master. So sound exchange is some of the money that is generated from the master. Sound exchange can pay that producer directly. So usually what will happen is we'll tell sound exchange, hey, producer is supposed to get whatever it is, 15%, whatever that percentage is on this master. It comes out of the featured artist share. So when sound exchange collects money, they basically 50% goes to the label, the copyright owner, and then the other 50% goes to the artists, 45% to the featured artist, 5% to the non-featured artist. So the producer's royalty from sound exchange comes out of that featured artist at 45%. Maybe a little bit technical, but depending on how much you've dealt with sound exchange, this may or may not ring clear or true. Certainly happy to answer questions about that later. But it is, again, it's something that we include in a producer agreement. So I certainly want to explain it and mention it so it doesn't catch you off guard next time you're working or dealing with a producer agreement. So the thing that gets attached to the producer agreement is something called a letter of direction. A letter of direction is a letter directing somebody to pay someone else. So it's an LOD or something. What is an LOD? What's a load or a lot? Or a letter of direction is a letter directing someone to make a payment. So in the sound exchange example, we have a letter that tells Sound Exchange to pay the producer his or her percentage. And that letter of direction, it is a standard form. You can download it from soundexchange.com. You do not have to write it yourself. They want you to use their form. That is what they go by. So, and they have there's a repertoire chart. So attached to that is a chart that basically you list the name of the song, you list the name of the producer, the artist, and everybody's number and percentages. And it's not complicated. I mean, in the grand scheme of things. And then we fill out that LOD and we attach it to the producer agreement. So it's all part of the same document. So we all know everybody who has to get paid. We also sometimes use LODs for labels or distributors, right? So we're saying we are directing the label or the distributor to pay a certain royalty to the producer. It's a really simple letter. I mean, it's a few lines, not complicated at all. Also, again, gets attached to the producer agreement. As I mentioned a few minutes ago, we can also, a lot of the online distributors like our DistroKids will pay directly. So that can save us a lot of trouble and make it happen automatically so that the artist doesn't have to worry about making those payments, calculating those payments. One thing I often remind people whenever it comes to a royalty or a percentage, an ongoing payment obligation is to think about, I said a little while ago that the copyright lasts for 70 years after the life of the author. Okay, so I write a song today, I go record it with a producer. I promise to pay that producer 15%. I'm paying 15% for 70 years after my life. The long obligation to make payment when we're talking about a percentage of the revenue from a song or from any piece of art, any copyright. So something to think about in the sense of like, who's got that obligation? How are we going to fulfill that obligation? Maybe we just rather pay more upfront and not have to deal with the percentage. I don't know. It varies, but I've certainly had conversations with clients where they say, okay, well, I'm going to pay a royalty. And it's like, okay, but think ahead about 20 years from now, how's that royalty going to be paid? If DistroKid's dealing with it, great. But if you're going to be calculating a percentage every month, are you prepared to do that for that long into the future? So that's a lot about the money. Let's also talk about the rights, because this is really important. I talked about copyright at the beginning. I'm talking about who owns the copyright. Really important stuff, right? So generally, the artist is going to own, or the label will own the sound recording. Now, why is this relevant in a producer agreement? Well, a producer is contributing to the creation of the sound recording copyright. And as I said, anyone who contributes to the creation of a copyright, by default, is a co-owner of that copyright. So by default, a producer could say, hey, I helped you record that song. I co-own that master copyright with you. That sound recording copyright. That's not generally what we want. Generally, the artist or label is going to own the entire sound recording, not giving a piece of ownership to the producer. And this is also an important thing conceptually. Getting a piece of revenue from the master doesn't have to equal a piece of ownership, right? The producer could be getting 3 points or 15% without owning 15%. Right? You can pay a royalty. As this recording artist, I paid the producer's flat fee or her flat fee. I can own the entire sound recording copyright. And I just owe them a royalty, a percentage, without the producer actually owning any piece of that copyright. And that makes it a lot more simple if I do want to go sign a label deal. I do want to go do a sync license or a sample. Okay, it's easier if I own the entire copyright than having to get getting permission from all the different copyright owners. Of course, that's more from the artist side, but this is pretty typical of a producer agreement. So that means a producer agreement has to have work for hire language. It has to have language, and usually the way work for hire language is stated in a contract is it says the producer's contribution to the sound recording is a work for hire owned by the artist. In the event it is not a work for hire, the producer promises to transfer to the artist all rights in the sound recording copyright. So again, this is kind of the art form of drafting contracts, and I can talk contract, right? I can speak just like I would write a contract, but things to think about when you're reading, writing, dealing with a producer agreement, because all this language really matters. It really matters, especially, as I say, if something goes wrong. The other copyright is relevant here. I've been talking about ownership of the sound recording copyright. What about ownership of the composition or the publishing? Okay, if the producer is contributing to the songwriting, for lack of a better term, the producer may have some publishing rights, may have some ownership in the composition. Very common. But again, let's think ahead about that. If you are an artist and you're going in the studio with everything fully written and you feel like, producer, has value here, but producer's not going to have any points, any publishing, not going to have any ownership of the composition. Versus, I've got the form, the song is pretty well formed, but this producer is great. And the reason I want to work with this producer is because I think she's got some great talent and wants to contribute. And so maybe that producer is going to get some of the publishing. So think ahead about that, because if the producer owns some of the publishing, they will then get publishing royalties, right? So percentage of mechanicals, a percentage of ASCAP or BMI, which, by the way, that was week 2, because we talked about publishing royalties. So you can go back and revisit that video. But again, thinking ahead about ownership rights, how these things are going to play out. Okay, so is the producer likely to have any of the publishing? Producer generally gets credit, right? Produced by. And so having that clause in the producer agreement makes sense. Also because sometimes we get kind of detailed about the producer credit, when it has to be used or when it doesn't. And oftentimes there's going to be a clause in there about what happens if producer number 1 works on the track and then an artist takes that track to producer number 2. Well, there's going to be 2 produced by credits. How do we deal with that? So these things do come up, and we want to be thinking ahead about how it's going to play out. And the last thing I think in this when we're talking about producer agreements, is just, we'll usually have a clause in there about inclusion of any samples, because if we are sampling, we're going to have to get those rights. I'm going to talk about that in a little bit. And so including whether there's a sample, who pays for that sample, whether it's been cleared, all those things is something we often want to put in a producer agreement ahead of time, so we know how we're going to deal with that. So I will pause here and take a drink. If anyone has that's pretty much my slides on producer agreements. If I left out anything, please pop a question in the chat while I sip my water here. Either there's no questions, or I've stunned you all and no one can even keep up. So I hope that's not the case.
I have
but actually,
quick question, if I could just ask you.
Sure, go ahead, Miles.
Yeah. So I guess as a producer, what is considered contributing to the writing? Like, do you actually have to work on the lyrics, or is there still like a instrumentational portion you can add to it and get part of that?
So thanks for the question. And this is really case by case. And actually, it is something I did talk about in week 2. So go check out that video. But I will say, because every song and every genre of music is different, it really does very certainly contributing to the instrumentation or the music underneath the lyrics is certainly a contribution, and that is often worthy of a piece of the publishing. How we calculate that really varies, and every artist is different and every song is different in how we do that. Because, for example, like I have some artists say, well, 50% for the music and 50% for the lyrics, but certainly that doesn't apply in instrumental music, right? So yes, contributing to the instrumentation or the musical side of the song is a contribution to the composition, and will often result in a piece of the publishing. But what percentage really is going to vary on the song. So, and it really is, it's an important conversation in any songwriting scenario, whether that's songwriting in advance or songwriting during the recording process. It's really important to have those conversations so that everybody in the room is clear on who owns what or what the expectation is. That's why we have split sheets. So split sheets, not to keep referencing another thing we talked about in week 2, a document that just says, here's the name of the song, here's the name of all the contributors with their percentages. So want to have a good thing in there. Make sure that's clear. I see Brian said, if you're a producer who owns a label, would it make sense to combine their producer agreement and master recording agreement, how that would work? Really good question, pre-situation specific. I have done it that way. I have done recording agreements that have a producer clause in there, but we usually still use a separate producer agreement because the record label is usually a company. The producer is usually a human being, an individual. Those are separate under the law, right? A company is a separate person under the law. So generally, the recording agreement, if the recording agreement is with the label, the producer agreement is usually with the producer. And we can cross-reference them, but oftentimes we are keeping them separate. There can be room to combine them, but it is a very case-by-case thing. So, but great question. So I want to jump into, and thank you both for those questions. I'll jump into engineering agreements just because they are very similar to producer agreements, in that a lot of the terms we're covering are the same, are very similar. Now, of course, the amount paid is going to be different. The deliverable may be different, but the kind of headings, right, the paragraph names, excuse me, are going to be very similar because we're still dealing with someone who is technically contributing to the song but isn't a musician. Or sorry, technically contributing to the sound recording, but isn't a musician usually playing on the track. Now, I recognize sometimes producers do play on the track. That is why we have a work for hire client language in there. But the engineer, and since the engineer usually plays a lesser creative role, there are some differences that reflect that, that difference. Nothing against engineers, all very valuable, just kind of helping to explain why we have some differences between producer agreements and engineer agreements. The payment structure and the amount is often different. Again, the payment still will be usually a flat fee and royalty, but it's a different amount than we're paying the producer. That's why it's a different payment structure or different payment amount. And the specificity on the deliverables, again, because what the engineer is creating is a little different than what the producer is creating. We want to be very specific about what the engineer has to deliver, when they have to deliver, if there's multiple mixes, if they're delivering the stems, all those sorts of things. And credit is obviously going to be different. Producers are usually credited more frequently than the engineer. Not that engineers don't get credit, just like where is a credit required? For example, where is it optional? So a few things that are different. But again, a lot of times the structure of a producer agreement is pretty similar to the structure of an engineer agreement. So things that are similar, like that the parties are going to be the engineer on one side and the artist or the label on the other side. We're going to have the delivery timeline, so it's very clear about when those deliverables are due, and a payment timeline as well. That's a flat fee, oftentimes a royalty. Also, the artist is generally going to own the master. So, although the engineer's contributions aren't usually considered part of the copyright, but still language we're going to put in there to make sure that's clear, that the engineer doesn't have any claim to the ownership of the master copyright or the sound recording copyright. And engineers are less likely to get publishing. A lot of times I do see sometimes engineers being given publishing kind of in lieu of a flat fee payment or in lieu of money up front, with the assumption that the publishing will make money down the road. So it's kind of like, well, I can't pay you as much, but let me give you some of the publishing as compensation otherwise. So that sometimes happens. But it is really, well, as with every contract, it is case by case, depending on the contributions of the engineer, what we're paying them, and so on. But again, these contracts are very similar, and we use a lot of the same language, a lot of the same headings, a lot of the same structure when we're doing those two different types of agreements. So that a lot of the stuff we talked about, or that I was talking about regarding producer agreements, is also going to apply to engineering agreements. So looking at the time, I want to make sure I keep moving here. The next thing that is the major header on our list is sync licenses. So sync licenses, well, first of all, sync stands for synchronization, right? So a sync license is a license to synchronize music with a moving image. Moving images, things like TV shows, movies, video, any video games, anything that has a moving image, like I am right now. Right? If I wanted to play music in the background of this video while we're recording it, I would need a sync license to include that music in the moving image of this video. So anytime there is music in a video, we need the rights to synchronize that music with that video. And I know a lot of you will say there's all this music all over YouTube and no one's getting sync licenses. And I know that happens a lot. There's a number of reasons that happens that I probably could go down a rabbit hole and talk about, but I can just tell you that this is true universally. I've had clients who had put a video on YouTube with music they didn't get permission from and then did get sued by the person who owns the music. So don't think that just because other people are doing it, you can do it too. I know most of us on here are musicians. We're not looking to infringe other people's copyrights or steal music, but I'm still going to take the opportunity to say it. When we talk about synchronizing music with a moving image, it's important to remember we're talking about both copyrights, right? Because if I say, hey, I want to use that recording on my video, well, I can't use that recording without also using the underlying composition, right? So both copyrights are being synchronized. Both copyrights are included in that synchronization of music. And so when we talk about, I think the title, the heading of this presentation might have been sync and master use licenses. Well, we refer to the sync license as the license for the composition or the publishing. And we refer to the master use license as the license for synchronizing the sound recording or the master. But they are very, very similar because basically what we're doing is we're getting permission to synchronize that music with a moving image. But keep in mind, the owner of the composition and the owner of this master are often different. Traditionally, if we're saying that a publishing company may control the composition or the publishing, a record label may control the master or the sound recording, or a distributor controls the sound recording or the master. So we're getting the rights from two different parties. Now, I know a lot of us as independent musicians, a lot of times we own everything, right? If I'm an independent musician, I may own all my composition rights. I may own all my sound recording rights, but not always. And so if you are if you're the musician doing this, maybe you can grant both of these sync licenses or both of these licenses, the sync and the master use, because you own all those rights. But if you've signed a distribution deal, well, you may have given the distributor the right to grant synchronization licenses. So you can say, well, I control my publishing, so I'll grant that sync license, but the master use license has to come from the distributor. So it's hard. I can't give you one situation that encompasses all the examples, or one example that encompasses all situations. But again, we want to just be thinking about both copyrights when we're doing this, because a sync is going to generally require both copyrights. Sync licenses, the language on this slide says that the terms and fees are individually negotiated. What I mean by that is each sync deal is different, right? So it's not like, oh, there's a set fee and all sync, every sync is $500. It just doesn't work that way. Because there are so many different terms that we're going to incorporate into the sync license. And when I say a sync license, I'm thinking of a license agreement, right? A contract. Because as I said earlier, we want to have anytime there's a deal that has something value being exchanged, we want to have it in writing. So we're going to want to have these sync licenses in writing whenever possible, and also with as much detail as possible. So one of the most overlooked terms in a sync license, it's kind of funny, is the grant of rights. And people think, well, what do you mean? I grant you the rights to put in your, let's say we'll use a film as an example. Sure. You grant me the right. I'm a film producer. You're a musician. I say, I want to put your music in my film. And you say, okay. And we agree on the money. Okay. Well, you don't have to give me the rights to do everything with my film. You could say, well, I'm going to give you the rights to use my music in your film just on television, but not for a theatrical release. Or more often, it's just for film festivals, because what filmmakers do is they will make a film, take it to film festivals to try and sell it to a distributor, and then come back and say, okay, now the distributor has money to go pay for the rights to synchronize the music for the rest of the distribution, theatrical, television, whatever else. Another example, let's say you are, someone wants to use your music in a socials post, right? They want to use it on TikTok or in their own, TikTok, there's a library, and again, that's a whole rabbit hole about the music libraries on the social media. But let's just say that I'm a social media marketer, and I come to you and say, my client, I'm representing this law firm, and they want to make some videos, and they want to use your music in their videos. So we're going to license your music you're going to say, okay, well, it's this much if you want to use it in these social media posts, but if you want to, let's say, use it on television, you're going to run ads on TV, well, I'm going to charge you more. Right? So specifying exactly what use is allowed under the sync license is really important. Now, you just may say, use it for whatever you want, use it anywhere you want. That we would call all media, like this last bullet point on this slide. And that's fine. We just want to specify. As the artist or as the copyright holder, it allows the different grants of rights can allow you to kind of name different prices, ideally make more money from the license. But also, it's just about that specificity, right? It's about the contract being specific so we know what the deal is. We know the who, what, when, where, why, how. And so we want to include those details about exactly what rights can be used. Now, the other thing we're going to include is how is the music being used in this moving picture, in this video, like better term, because that also affects how much we can charge as an artist. So if, let's say we're going back to the movie example, if the music is just playing in the background during a scene, well then not as prominent use. But if it is in the foreground, let's say someone is on stage singing our song in the movie, well, that is a more prominent use, gets us more money. Similarly, if the music is used in the opening or closing credits, more value. And certainly if it's the theme song of a television show or an episodic series, a lot more value. So you can charge more if it is, for example, a theme song. Right? So you want to specify, it's not just, oh, you can put my music in your movie, but hey, where is it going to be used in the movie? Because if it is the opening credits, that's significant. That's important. And I want more money for that. Okay. Similarly, how much of the song is being used? Are we using a 10-second clip or are we running the entire track? It's pretty rare to run the entire track, right? So if they did want to run the entire track, we'd want to charge more money if we are the musician. If you're the filmmaker, you want to pay as little as possible. But these are details we want to include. Is it exclusive or non-exclusive? In other words, if I'm the filmmaker and I say, I'm using your music as my opening credits, I don't want you putting your music anywhere else in any other film. That's an exclusive license. Only I can put it in the film. And that would mean I should pay more, right? Because you're taking it off the market for all other films. Most sync licenses tend to be non-exclusive, exception being for advertisements, right? Because a lot of times advertisers are trying to, convey a certain vibe for their product or service, I guess. But it may be exclusive for an advertising, it may be exclusive just to a genre. So for example, if I'm making ads for my law firm and I'm going to synchronize your music in the ads for my law firm, I'm going to say, I have exclusive rights to use your music among law firms. If you want to go license it to a plumbing company or a toy company, that's fine, but you can't license it to any other law firms, right? And so these are all examples of all the details we want to include in these sync licenses, in these contracts, so that there's not a problem when later on, we do see it being used somewhere else, or we do use the entire song, we didn't think that was happening. All those sorts of details, including the last line on the slide, that whether changes or edits can be made, can the person using or licensing the music make any changes or edits? Usually we say that they can use a truncated version. In other words, they can use a clip of the song. They just can't actually edit the song or change the song. Pretty standard. But again, think about it, because that is something we want to cover if it is relevant. Sync fees, how much we're getting paid is really important. Always how much we're getting paid is really important. And fees can be really lucrative. You can charge a lot for music in film, depending on a lot of factors, obviously. Depending on how popular the music is and depending how big of the production is that the video is in. But I can certainly tell you that music that is everyday music, if you're on the filmmaker side, or you moonlight in advertising or something, you should know that if you wanted to use music that is very common, that is popular on the radio, that is getting millions and millions of streams, it can get very, very expensive. And ideally, as an artist, as a musical artist, you can make lots of money by doing syncs. And that is a great revenue stream if we can get it. So Obviously, beware as an artist, beware of offers where someone says, I'm going to put your music in my movie. It's going to give you great exposure. I can't pay you, but that's a sign. We don't want to give it away for free if we can avoid it. Now, I'm not giving you legal advice here. Nothing I say tonight is legal advice. I'm not your attorney. You can give your music away for free if you want, but it's just something to be aware of, okay? Because normally there's a flat fee involved. Normally, it's going to be $1,000 to use it based on all those terms that I was just explaining. But it's not usually royalty based. We're not usually, as the musician or as the owner of the music copyright, getting paid based on how much money the film makes or how many times the advertisement is shown. It's usually a flat fee, so we don't have a royalty obligation going forward. As I alluded to, a more prominent use is generally worth more, so we charge more for that. And the fee can be for one or both of the copyrights, or we call it the sides. So in an example where I'm a recording artist and I'm a songwriter, so I wrote the song, I own the composition copyright, I recorded, I own the sound recording copyright, I could do one fee for both sides, for both copyrights. Now, if it is different, if there's a label and a publisher involved, they're going to get their separate fees. This is an opportunity for me to mention something called Most Favored Nation, an MFN clause. Some of you may have heard of MFN clauses or Most Favored Nation clauses. What this means is everybody gets paid the same amount. Everyone is, no nation, no party is favored over another. So what a Most Favored Nation is, that if, for example, the filmmaker goes to the publisher and says, publisher, I will pay you $1,000 to use that composition of that song in my movie. And then the filmmaker goes to the label and says, record label, I want to use the sound recording of your song. And the record label says, well, it's only 500, but I want a Most Favored Nations clause. That means the label has to be favored just as much as the other nation as the publisher. So if the label has a Most Favored Nation clause in their contract, in that sync license, that means they're going to have to get 1,000 because the publisher got 1,000. So it's always something to think about. And we commonly see Most Favored Nation clauses in sync licenses because in a film where there's going to be 15 different songs in the film, all the people granting sync licenses to this film want to make sure they're not losing out and getting paid less than they could have made. So everybody puts Most Favored Nation clauses in their contract to make sure they are as favored as everybody else who's licensing music to the film. So one other thing to think about when it comes to the money is that when music is put into a moving image, into a TV show, film, advertisement, once that moving image is broadcast, once it's shown, once it's played over any speaker anywhere, it is generating performance royalties. Okay, so that's what our ASCAP and BMI are for, right? ASCAP, BMI, CSAC, those are performing rights organizations. Again, we talked about in week 2. And they collect for the public performance of the music, of the composition. So when music is played in a movie or played in a TV show, ASCAP, BMI are collecting for that performance of that music in that show or that movie. So that is great if you are a songwriter, if you own your publishing rights, or even if you're just getting your publishing revenue, fantastic. You're going to not only get your flat fee for the sync, but if this moving image, if this TV show, film, whatever it is, gets a lot of play, it's going to generate PRO money. It's going to generate ASCAP, BMI, or performance royalties. Beware, because sometimes a sync license will sneak in language that says that you're granting them a free performance license. So be careful of that if you are a rights holder, if you're a songwriter, because you ideally want to get as much revenue as possible from this use. And therefore, we want to make sure we're getting our PRO money, our ASCAP BMI money, when that movie is out on TV everywhere, or out streaming everywhere, I should say. So a lot of things to think about with sync licenses. And again, I will stop here and take a sip before I jump into sampling, in case anyone wants to post a question in the chat, or certainly save your questions for the end. That's fine as well. Fantastic. We are moving right along. I know you're all getting sick of just hearing my voice. We're got another 15, 20 minutes left, and the last thing we're going to talk about is sampling. So Sampling is basically using an existing recording in a new recording. Now, it sounds kind of obvious, but I just want to lay the groundwork here. And sampling is obviously very common in a lot of genres of music. It has become much more common than it was when I was growing up. Not to date myself, but it is definitely far more common now, and therefore it's very important for us to think about when we're talking about sampling, because so many songs are built on other songs or include a sample of another song. And it's also important to remember that if we're using someone else's record, if we're sampling a recording, okay, that also means we're sampling the composition, right? If I'm sampling a recording, well, that underlying composition is part of that sample. I can't separate them. So again, we're covering both copyrights in this licensing scenario. We're using someone else's copyright, but we're using both copyrights if we are sampling a recording. And even if there's certainly situations where we say, I love that beat, but I'm just going to re-record it myself. Well, you're still using the original composition. You're just creating a new sound recording. So in that situation, we're sampling the composition, and we still have to get a sample license for the composition, even if we are we're creating our own new recording. This also, by the way, applies to sync licensing. This does happen sometimes where they'll say, oh, well, I really love that song. I want it in my movie, but I'm going to create a new recording of it. You're still going to need a sync license for the underlying composition, even though we're creating a new sound recording that we might own and be able to sync. So a lot of similarities in that respect of using both copyrights or making sure we're thinking about both copyrights when we're licensing or using someone else's music. Common misconception or thing I want to make sure to clarify is that I've heard people say, oh, well, I know that if I use less than 3 bars, I use less than 6 notes, I use less than whatever amount, then I don't have to get a license. Then it's a free sample. There is no minimum amount that requires a license. We've had so many different lawsuits about this, so many different cases about this, that we don't have a controlling standard. And therefore, I can say there are samples short enough that they may not need a license, but I can't tell you how short that is. And I generally would say anything that could be recognizable needs a license, because we have examples of lawsuits where it is such a short clip that even the naked ear, even this common listener, isn't going to catch it. But someone with a trained ear does catch it, and then we have a lawsuit. So if you are sampling, again, I'm not giving legal advice tonight, but it's really a good idea to get a license, if at all possible, and avoid a lawsuit. So the sampling of the master is going to be from the master owner. That may be obvious, but the master owner may often be a label, right? Sometimes a distributor, sometimes as the recording artist. I know that happens a lot as well. But we have to, a lot of times, if we are sampling, a lot of times we're sampling something we've heard, something that's more common out there. So we're usually contacting a label to get a sample license. The fee to sample a master is usually a royalty plus an advance. It's a recoupable royalty. What that means is that I'm going to sample this track in my new track, and there's going to be $1,000 advance. Okay. And then there's going to be a royalty, and that royalty is usually based on use. So it's per download, per stream, per sale. And so the advance is a recoupable advance, recoupable from the royalty. So let's say it's $1,000 is the advance, and it's going to be 10 cents per sale. Okay. So after 10,000 sales, we've made $1,000 worth of sales. Then the royalty starts getting paid. We've recouped the royalty we've recouped the advance out of the royalty. Right? Advance is what it says. It's an advance payment, right? That usually has to be recouped. So that's usually the structure for a sample license, is that there's a guaranteed payment to the owner of the master, because they want to make sure they get paid. If no one ever buys this new track, they still want to make sure they get paid. And then that advance is usually recoupable from the established royalty. Certainly, the owner of the original is usually credited for the use of their sample, the use of their master in this new track. Another thing to think about and I talked about this for a moment regarding producer agreements, is that if the producer is sampling or if the producer is inserting the sample, well, does the producer have to pay for that? That's something to think about if you are an artist engaging a producer and the producer says, oh, well, a sample would be great here. Well, who's going to pay for that? So something to think about if you are in that situation, basically, if you're hiring a producer and there's a sample going in there. So and I think, by the way, I will also mention, everything I'm talking about today is general, right? Every contract is different. Every deal is different. I'm definitely talking about what we're most commonly seeing. I see other things as well. And I think that the purpose of today is to really give you the general guidelines of how things normally work. It doesn't mean it's the only way things can work. But these are general terms for sampling a master. And then, as I said, if we're sampling a master, we also have to get the license of the composition that is embodied in that master. So, of course, that license, the sampling for the composition or the publishing, generally is going to come from who owns that composition copyright, which a publisher will often own and control those rights. Songwriters that own their own publishing, that's fine as well. But it is also often a royalty plus an advance. So very similar to what I was just talking about regarding the sampling of the master. But one thing that you also want to think about is that a mechanical royalty is going to be due. And we talked about mechanicals in week 2. So this is why there's some synchronicity between me doing weeks 2, 4, and 6 and Max doing weeks 1, 3, and 5. And so we want to think about the mechanical royalty that will be due by sampling this composition, because we're creating a mechanical license for mechanical royalty is due for the mechanical reproduction of a composition in a recording. Okay, mechanical royalty is due when we mechanically reproduce a composition in a recording. So here, we are taking that original composition in that sample and we're putting it in a new recording. So that generates a mechanical license or mechanical royalty. So we want to be negotiating that as well, because that's money that's going to have to be due, and we want to be thinking about all the money that's going to come from this, whichever side you're on, right? Certainly the original songwriter is often credited, and if there is a publisher, it's usually courtesy of the publisher. It's often the credit we get for sampling. There's a little bit more complexity to the fee for sample licenses, for sampling the composition, because the owner of the original composition oftentimes will get a percentage of ownership in the new composition. So I wrote a song, and I've dealt with this, I wrote a song 40 years ago. Okay, and someone says, oh, I just found this track on this vinyl in my dad's basement. I love it. I want to sample it. And we're going to dig it out, and we're just going to use the hook. We're just going to use a few bars. And we're going to use that few bars in this new recording. Okay. Well, you're creating this new composition based on this 40-year-old composition. That owner of that 40-year-old composition is going to get a piece of ownership of the new composition. And if it's the hook, it's going to be a significant portion, 25, 50, even 75%. The percentage ownership that you get that the original artist or the original songwriter gets in the new song is not equal to, generally, not equal to the percentage of the original in the song. What I mean by that is, let's say we've got a 4-minute track. The sample is only 12 seconds. That's really hard math for me to do in my head, but let's say that's 5% of the song. That's probably not even good math. If I was good at math, I wouldn't have had to go to law school. So the sample we're using may only be 5% of the new one, of the new composition. But the owner of that sample, especially if it's the hook, is going to get 50% of the new composition of ownership. Okay, so something to think about when you're sampling. If you're using a lot of samples, you only have so much to give. And also there's a cost there because you're giving up a percentage of the publishing and therefore a percentage of the publishing revenue. And so that is common. It's not universal. It doesn't happen in every sample deal, every sample license. But even if if the original songwriter isn't getting a percentage of the new song, of the new composition, they're still going to get a royalty. And that royalty will generally be outsized as well, right? Even if it's only 5% of the song, it's 50% of the revenue. So things to think about when considering sampling, right, is how that's going to play out in the final calculation. The last thing that I will mention is similar to what we were talking about with royalties in the producer agreement, is specifying what that royalty payment schedule is, and that so whether it's monthly, quarterly, annually, within a certain amount of time, who's paying those royalties? Is it coming from the other publisher or from the distributor? Wherever these monies are coming from, make sure those details are included in these sample licenses. If I'm paying someone to sample their music, I want them to promise that they own those rights and they can grant those rights, and that what they did doesn't infringe someone else's rights. We often call these representations and warranties. When you see representations and warranties in a contract, it basically means promises. So I, as a new artist, want the sample owner to promise they actually have the rights. They own those rights. They can grant me the rights. Because what I don't want to happen is someone else to come out of the woodwork and say, oh, no, that was mine. You owe me money too. Right? I know we have a lot of writers on a lot of different songs, right? And so we want to make sure we have the rights from all the writers or all the owners. In a sample license, beware if you are sampling and you're getting a license from that copyright owner, read the fine print, read everything in the contract, because there may be limitations in there, like, oh, you can only use this for 10,000 streams, or you can only press 100 copies of vinyl on it, things like that. And also think about if you're sampling music to be included in your new track, include a clause in there that says you can use the sample in a video, because as we talked about, synchronizing music with a moving image in a music video, requires a synchronization license. So you don't want to complete this whole sample license and pay for the sample and then realize, oh, well, now I want to make a video. I got to go back and get a sync license and pay more, right? So be thinking ahead, kind of going back to the original, think about the whole story, think about what can go wrong, think about all the different possibilities of this use, so we have everything in these license agreements that covers all the uses we're planning on. So that is all I'm going to say about samples, also because we're running short on time here. So recap very, very briefly that we always want to use a contract anytime there's any sort of deal with value changing hands in any way. Think about the contract telling a story when you're reading a contract, working on a contract, asking for a contract. Include all the points in that story. Don't leave anything out. Producer and engineer agreements, think about the rights and responsibilities, right? Ownership of the copyright, payment terms, all those things about the who, what, when, where, why, how. And when we're doing sync licenses, think about both sides, right? Both copyrights, so we have to get a synchronization license, not only for the master, but for the underlying composition. And also that sampling gives lots of, if we are going to use a sample, think about how much we have to give away to those original owners, whether it's a royalty or ownership or both, because a lot of samples can turn into a lot less money for the new artist who's using those samples. So that is what I've got planned. We've got a few minutes left, so feel free to throw some questions in the chat and I'll answer them as quick as I can. Miles asks, as a producer looking at a contract in terms of payment, I need to make sure there's discussion of master points, master percentage, pub royalty, and flat fee. So yes, points. So the master points and royalty are basically two different versions. Points is a royalty calculation. Okay, points is a percentage of revenue generated. It's just that the way we calculate points and the way we calculate a percentage of revenue is different, because the points is calculated as percentage of the retail price versus a royalty calculated as percentage, let's say, of the net revenue, the money brought in less the expenses. And yes, as a producer, if you are helping, if you're contributing to the songwriting, you may also get a publishing percentage, right? Splits on the publishing. And yes, as a producer, you can get a flat fee per track or per album. So these can be a lot of different, there's a lot of different numbers to play with. Every deal is different. You get paid, a producer gets paid for streams because streams are generating revenue, right? I mean, streams is distribution revenue, or streams are for the distribution of the master. Okay, so the money, there's revenue streams from the master, there's revenue streams from the composition or the publishing. And so streams are generally come in as revenue from the master. So if you are getting a percentage of revenue from the master, well, that's the point size of things, right? Let's say you're getting 15% of net revenue on the master, you're getting 15% of the streaming revenue after recoupment of the expenses. I know this stuff is complicated. I hate to say that this is why I have a job, right? It's just like, I realize this, to be clear, this presentation is not meant to say, well, now you can go and write your own producer agreement. But hopefully it's, it was really meant to cover those major deal points. I know this stuff is complicated. And the way that I try to conceive of it is there are two different copyrights. Okay, we've got the master copyright, we've got the composition or the publishing. And each of those copyrights have their own revenue streams. So we think about the master generates revenue from distribution and from sync, from sales of whether it's streaming, downloads, vinyl. The publishing generates revenue from, and the master also generates sound exchange, performance revenue. The publishing generates revenue from performance rights, PROs, ASCAP, and BMI. It generates revenue from mechanical licensing and generates revenue from sync and from samples as well. So that's a way for me that's helpful in breaking it down in my own head, anyway. Any other questions that anyone may have? Well, I think we're pretty much getting right on time here. So what I'd say is if you do have questions that you think about in the middle of the night, feel free to send me an email. That's why my email is on here, and my phone number is on there, or our office number is on there. CreativeLawNetwork.com also has a lot of information. CAFTA, Colorado Attorneys for the Arts, has a lot of information. CMIA is getting a lot of information out there. We're all working together on these things. But definitely please do, and if you want to revisit this video later, CAFTA is going to post it. You'll get the link to that. Go revisit the past 3 weeks, and please sign up for weeks 5 and 6. Max will be back. Max Haas will be the attorney teaching week 5. I'll be back for week 6. Thank you all for listening to me tonight.
Thank you, Dave. Really appreciate it and laying out some very complicated information in an accessible way. You did a great wrap up, so I'll just say good night. Thanks, everyone.